Right now on the Daily Debrief, millionaire Robert Durst tries to convince a court that material from an HBO documentary should be thrown out of his upcoming trial. And
it is the age of the victim that is the aggravating factor.
Attorneys choose a jury in the case of a cheerleader accused of murdering her newborn baby. Her family says the child was stillborn. Also,
clearly her own statements had a huge effect on the outcome.
Reaction from an attorney who represented a Florida crime scene investigator convicted of killing a former police officer. The Daily Debrief recaps the day in court. It's Tuesday, September 3rd. And welcome to the Debrief, everybody. Aaron Keller along with you. We have a lot to talk about tonight, including the millionaire real estate mogul facing murder charges. He was in court today trying to block evidence from coming into his upcoming trial. Robert Durst is accused of killing his friend Susan Berman 2 decades ago. His attorneys want a judge to rule that HBO filmmakers were actually government agents and to keep the film out of the upcoming case. Prosecutors believe Durst killed Berman because she had information about the unsolved disappearance of Durst's wife in 1982. Durst was acquitted of murder in Texas. The prosecutor today shot back at the defense and said there is plenty of evidence to convict.
I've been doing this job, not as long as Mr. Ray, but 25 years. Done a lot of homicide trials, a lot of preliminary hearings, seen a lot of them, etc. I believe that the amount of evidence put on at this preliminary hearing is probably more evidence that's been put on in any murder case that I can remember happening in Los Angeles County, admissible evidence. So the idea that somehow there was faulty evidence, inadmissible evidence, a lack of evidence, just doesn't work. We have litigated these motions over and over again. We've litigated 1390 4 different times. This is a classic 1390 case. The court made the findings after having a detailed hearing, detailed arguments on 3 different occasions. It was properly admitted. Susan Berman was killed because she was a witness, because she helped Mr. Durst originally cover up the death of his wife, Kathy. She has stated that to numerous individuals. Mr. Ray gets up here and he says, well, Judge, I'd like you to assess the credibility of that evidence. The court very quickly responds, wait, Mr. Ray, is that my job? The court knows it isn't. I think Mr. Ray, he's in a tough position. There's not a whole lot for him to argue. But even if we wanted to somehow look at the credibility of these witnesses, we have somewhere in the area of 10 different witnesses coming in here and saying similar things about statements Susan made under forfeiture by wrongdoing. The court's ruled. It was properly admitted evidence, and it's a classic witness-killing case.
A lot to talk about there. Gabriel Sepulveda Sanchez and Janina Tamian are with me here in studios. Linda Kenny Bodden is in our newsroom tonight. So, Linda, let me start with you here if I can. What do you make of this? It sounded to me like the prosecutor was speaking to the public, to the press, just as much as he was to the judge there. What's your assessment?
Yeah, that's my feeling, because the motion was very specific that they were supposed to be discussing, which is, were the filmmakers, the 3 filmmakers, agents of the government for the purpose of you can't admit the statements at the jinx. But we went long beyond that there, Aaron.
There was a lot of evidence discussed right there. So, Gabriel, let me ask you about this. There's sort of that core question in there. Is the defense trying to stall things by asking the court to jump in and judge the credibility of a witness? Now, generally speaking, courts are not supposed to do that. That's for the jury to do, right?
Exactly. I think this is a defense tactic to stall the case out a little bit more and ultimately get rid of that evidence there. If they can get rid of that evidence, that's going to take this case to the next level for them.
Yeah, I mean, we're moving along here with this. Janina Tamian, your thoughts on this? I mean, you've got somebody who's a high-profile defendant in here. We've got another charge by the defense to try to keep things out of court. That's pretty run-of-the-mill. We're just paying attention to it at this point because of the defendant himself.
Well, I think that the defense has to take this shot because it's so incriminating. The idea that he is on TV unprovoked and makes this comment that, hey, I'm caught, I killed them all. I think it's so bad that they have to take a shot.
I mean, yeah, Linda Kenny Bodden here. The statements made in the film itself, that was part of the hearing today. We're just getting the video into Law&Crime now. We're still going through it as we speak. But the statements made to the film, they've been out there. Can they be perceived as an admission And if not, why not?
Well, they can be perceived as an admission, but they also can be perceived as he goes into the bathroom and he says, well, look, this is what just happened here. This is what they feel. Yeah, I killed them all, of course. Like he was being facetious or commenting on them, not commenting as a confession for himself.
Okay, so it might not be a confession, but again, I'm looking at this turning around saying that's for the jury to weigh, not to be kicked out in some sort of a pretrial hearing unless it's clear that there was police misconduct, which in this case, there wasn't police involved, Linda. Can filmmakers be government agents? I mean, let's back it up to that core question.
Yeah, Aaron, I'd like to respond to that. Yes, they can, but it depends on the interaction between them. But it's going to be very hard because, remember, we have jail informants who also talk to defendants, and they're not government agents under most circumstances. So it's a very difficult task, but they can. I mean,
look, Linda, filmmakers, government agents. Gabriel, what do you think on this? I just see free press. The press gathers information. It doesn't make them government agents.
It just depends. We discussed this earlier. We want to see what kind of contact they had with the filmmakers and what type of contact it was and when it happened. And it's an argument you could make.
A lot to uncover there. We're still going through the hearing that the judge held today in California in the Durst case. Meanwhile, a trial was set to begin today for actor Cuba Gooding Jr., but it's been pushed back about a month. October 10th, now the new trial date for that actor accused of sex abuse. Gooding is charged with forcible touching and third-degree sex abuse in an alleged groping incident from this past June. The actor has pleaded not guilty to both misdemeanors. Jury selection underway, and a jury has indeed just been seated in the trial of an Ohio cheerleader accused of murdering her newborn baby 2 days after her high school prom. The family of Brooke Skylar Richardson, however, says the infant was not murdered. They say in various interviews that the baby was stillborn and that Richardson buried it with flowers without telling anyone publicly because she was afraid of social backlash. Richardson faces a total of 5 charges. The top charge, aggravated murder, accuses the defendant of killing her baby with premeditated design. The defendant also charged with manslaughter, endangering children, tampering with evidence, and abusing a corpse. Attorneys today questioned an initial pool of 70 potential jurors. Attorneys are questioning 12 at a time to narrow things down to 20 prospective jurors. From there, each side had 4 peremptory strikes. Here is how the questioning of some of those jurors went from the prosecution.
When you had your children, were they born in the hospital?
Yes, one barely, but.
Okay. And why did you make the decision to have them in the hospital?
For their safety and my safety.
The child that barely made it to the hospital, what was that situation?
It was just not knowing what to expect. It was just unexpected.
Okay, unexpected. Did you get to the hospital in time?
Yes, about 10 minutes to spare.
Would you agree that having somebody there that knows what's happening, because this was your first child, correct, is important?
Yes.
Asking for help, assessing your safety as well as the child's safety?
Yes.
Giving attention to any possible medical needs? You've heard that the aggravating factor in this case is based on the victim's age. If I prove this case to you, I being myself and Mr. Knippen, beyond a reasonable doubt, would you be able to sign your name to a verdict form?
The defense asked the jury about the defendant's history with eating disorders and about pre-trial publicity.
Just by the mere accusations, the mere fact that Skylar buried a fetus or baby, and again, I'll use those interchangeably, I'm going to call Annabelle a baby throughout the whole trial, in the backyard. The mere accusation of that, does anyone lean just a little bit towards guilt on the murder count just because she buried her baby in the backyard? Skylar had a very serious eating disorder, has had it since she's the age of 12. The law says that Skylar or any mother cannot be punished for acts that occur when the child is actually in their belly before delivery. This case is not about abortion. Skylar, no one is claiming the prosecutor to believe or the defense that Skylar tried to have an abortion, did a self-abortion. That's not in this case. But what is in this case is that Skylar suffered from a serious eating disorder and did not get prenatal care in the 11 days after she found out certain that she was pregnant before the delivery.
Okay, let's bring the panel in to discuss this particular case. Linda Kenny-Bodden in the newsroom, Gabriel Sepulveda-Sanchez and Janine Atanian here in the studio with me. So Janine, these are relatively run-of-the-mill questions for a jury selection process. A lot of questions there about the pre-trial publicity. Did jurors listen to a lot of the coverage? And this is a case that went viral. It was in magazines, it was all over local television, it was all over national television. The attorneys need to ferret out anyone who has a hard, fast opinion.
Absolutely, but I was actually surprised because I was of the opinion that the venue should have been changed based on the Facebook groups that were kind of attacking her and the crowds outside the house, but I think that they seated a great jury today.
Okay, so Gabriel, what do you think here? Should the venue have been moved away from that Cincinnati area courthouse where this case is being held? Should it have been shoved up to Dayton or Cleveland or some other place? Ohio's a big enough state, you could seat a jury just about anywhere.
I think you wanted that trial to be moved to a different town. I grew up in a small town, and I know that it's easy for things to get out. Everyone knows each other, families know each other. Social media is big. It's easy to get a hold of information and find out what's going on. I do agree with Janine. I think they picked a really good jury today, though.
Linda Kenny-Bodden here. Let's talk about how this case is likely to play out. It looks like there's a big factual discrepancy here as to whether or not the baby was stillborn or whether the baby was the victim of premeditated murder in Ohio. This is going to boil down to the forensics. I think you and I agree with that.
Right. As a matter of fact, the state indicated to the jurors that they don't have any medical or scientific evidence that says the baby was born alive. They're going to rely on her, quote, confession, whereas the defense said they have a lot of medical and scientific evidence. And they also said to the juror a number of times, well, you know, you've seen your child being born. You cut the cord, indicating that the cord was not attached to the child here in this case. So that's where they're going. That's what they're going to say.
I don't know, Janine, what do you make of this? I mean, if this is not a case of premeditation beyond a reasonable doubt, could this thing blow up in the face of the prosecutor who filed this long list of charges here? Because it's a long list of charges. I could see people looking and saying, okay, you know, there's a disposal of a corpse here. Maybe that charge will stick because she basically admitted to that. But premeditated murder is a lot for the prosecution to try to prove here.
I don't think that they can meet that burden, but they also put in involuntary manslaughter because the thing is, you've got a baby. There's some evidence that says that there was the skull was crushed. There's talk of maybe there was some burning, different things that have come up. And so they may want to get her for something. I hate to say that, but involuntary murder is a lot easier to prove.
A lot easier than premeditation, certainly. We are going to be watching very carefully to see how the evidence comes out, because if the state doesn't have it beyond a reasonable doubt, then the jury is supposed to legally acquit on that top charge. And still ahead tonight here on The Debrief, a look at the conviction of Ashley McArthur. This is a case we followed last week. An attorney who litigated the case speaks freely with Law&Crime about the evidence against his client and his strategy moving forward for appeal. That's when we return right here on The Debrief. New reaction tonight in the case of a former Florida crime scene investigator accused of murdering a former police officer. Defendant Ashley McArthur was accused of shooting Taylor Wright in the back of the head and then hiding Wright's remains on property owned by McArthur's aunt. The state said the motive was money, but the defendant said she didn't do it. Here was the verdict after 3 hours of deliberation.
As to the charge, in count one, we the jury find the defendant, Ashley McArthur, guilty of first-degree premeditated murder with a firearm as charged in the indictment. So say we all. David A. Faust, foreperson, dated August 30th, 2019.
Ashley McArthur's attorney, John Barosset, reacted to that verdict today on the Law&Crime Network.
You know, obviously, we're very disappointed. I mean, we put years of preparation into this, and you know, we thought we had built a good defense. Obviously, Ms. Jensen did a great job. She had a lot of really good evidence on her side, but disappointed. But I think the most powerful thing is, and I guess the jury disagreed, is the state had all this time and they made no effort to do any type of forensic testing of this to say, yes, this is exactly the same concrete, because they knew the brand. I don't know who else could have done it. I wasn't really worried about that. We did check these people out. But we just didn't think they could prove Ashley did it. And it's not our job as defense attorneys to give them alternative. Of course, that would be nice. Yes, absolutely. I was trying to be upfront with the jury that clearly Mrs. McArthur was not completely honest and forthcoming with the police in these statements. And I think in my opening statement, I even said the phrase that she lied. You know, I was trying to take some of the wind out of the prosecutor's sails. This is a classic case for years to come that people can look back on and say, you know, clearly her own statements had a huge effect on the outcome of this case.
The defense said one avenue for appeal is what it calls a police lie designed to get the defendant in for questioning. And then there are those many pictures of guns.
Well, actually, I have not seen her since she left the courtroom on Friday afternoon. I will be going to see her later this week to tell her, of course, talk about all her options, including her appeal rights. We filed a motion to suppress her statement on October 19th, 2017, that she gave to law enforcement. In that statement, it came out at the hearing, not at the trial, but at the motion to suppress hearing, that law enforcement lied to get her down to the police station. They then put her in a room and kept her in there for 5 to 10 minutes by herself. They then came in and engaged in talk with her for probably 10 to 15 minutes. She got midstream Miranda warnings. The officer clearly downplayed the significance of those warnings, and we don't believe that statement should have been admitted into evidence. There was issues, of course, with the photograph being shown to the jury. I asked for a mistrial on that. I think that was a huge mistake given the nature of the charge and the allegation to have a gun being pointed by our client right at the jury. We moved in limine to keep the state from talking about the .38 that they put into evidence because there was really no connection, not really, there was no connection of that firearm to the murder of Taylor Wright, and just letting a random firearm into evidence we thought was extremely prejudicial.
Prosecutors used a series of photos to describe to the jury exactly where the victim's remains were dumped and buried under concrete and soil. Among the images were these pictures of a trailer and a barn, and then a wooded area behind the barn where the gruesome discovery was ultimately made. Prosecutors alleged that Ashley McArthur buried the victim's body, then topped it off with a potting soil and concrete that she purchased with cash, and then saved the receipt. Now, bottom line is this. The receipt led prosecutors to a nearby Home Depot where surveillance footage showed the defendant purchasing that fast-setting cement and potting soil. She told an employee there she was building a flower bed, and the employee said the defendant specifically wanted that fast-setting concrete. We also have a lot of points to make because back during the trial, witnesses and interrogation videos all indicated that the defendant did not like the victim. Here are a few of the unpleasant thoughts that our cameras captured.
She told me they'll never find that bitch. She's gone.
That the world would be a better place without Taylor.
What specifically did Ashley say about cocaine?
How much coke do you think it would take to kill somebody?
She's a strange girl. Taylor is a very tough person. She's always come across as being tough and never made it anything other than, she's always carrying weapons, whether it's knives or guns or whatever. She's not an easy target.
Okay, several defense witnesses said an injury prevented the defendant from committing the crime as charged. Another said he worked several jobs on the property where the victim's body was found, at times relevant to this investigation, and he said he saw nothing unusual.
So you were left out, as far as you know, you were out there on the farm by yourself?
Yes, sir.
Okay. Fair to say you probably were out there, give or take, 2 hours?
Hour, give or take, maybe an hour and a half.
All right. Did you notice to see any blood anywhere?
No, sir.
Okay. Did you see any, what appeared to be drag marks where something heavy could have been moved anywhere?
No, sir.
Did you see any indications around the property where it looked like maybe recently concrete had been made or anything like that?
No, sir.
What about any potting soil that was, not in pots, but in a different location, kind of unusual location sitting out anywhere?
No, sir.
Did you notice any unusual odors or smells that caught your attention?
No, sir.
What about the second visit?
No, sir.
First visit, any maggots or anything like that anywhere?
No, sir.
Second visit?
No, sir. Not a buzzard in the sky.
Okay, let's go back to the panel to discuss this case. Janine Atamian and Gabriel Sepulveda Sanchez in the studio here with me. Linda Kenny Bodden out in the newsroom. Linda, okay, we had a conviction here. Any surprise to you? What do you think?
I wasn't here last week, Aaron. I reread everything, watched everything. I could name that tune in like one note. Absolutely no surprise at all. That potting soil and that saccrete and that concrete, that was like, just, killer here, killer here. I mean, that was it.
I mean, look, Linda, this was a case that was circumstantial, but I think that the authorities did a good job of lining everything up and saying, okay, guess what? We don't have smoking gun evidence. We've got a lot of what ifs, and when the what ifs start to pile up, they really pile up, and I think that's what happened here.
Yes, and also remember, there's a motive. She stole $34,000. There's a further motive. We know that she lost her skimming of the amusement machines, the jukeboxes before that, so she probably needed money. And then she has hatred. I mean, you got everything here. It was an easy case. Okay, Gabriel Sepulveda Sanchez in studio with me here. What's your take on this? I mean, grounds for appeal here, as the defense attorney said today. Do you think they'll get any traction? One of the issues, those pictures of the guns, this Smith & Wesson revolver that prosecutors sort of insinuated might have been the weapon that the crime was committed with, but they don't know for sure. And then that big picture of that bazooka-like hunting rifle, the defendant's out hunting. Is that overly prejudicial? Is that enough to flip this case?
It's an argument. It's an argument they're going to make, and I think it's a decent one. But ultimately, I think because of all the other issues and all the other evidence involved, I don't think the Court of Appeals was going to see there's a prejudicial error in the decision that came.
The picture was up on the screen for like a split second. Did the jury even get a good look at it? That's another big question here. But let me boil this down even a little bit further here. Janine Atamian, your thoughts on this verdict? What do you think?
I think that the prosecution did a great job connecting all the dots. I don't think that the picture was prejudicial enough. It's not what tipped the hat. You know what I mean? There was more than enough evidence prior to that.
So the appeals court has to sort of weigh that and say, okay, well, is this harmless error, so to speak, the dreaded words that defense attorneys don't really like. But even if the jury saw it, even if it's a problem, there was sufficient evidence for us to let this conviction stand. That's your thought?
Absolutely.
Okay. Linda, we had this, your thought as well. Do you think that this appeal is going to stick? Do you think that the defense has a shot or not?
It's going to stick, Aaron. And remember, the judge sentenced her concurrent to her other 7-year on the fraud conviction. She basically got, a free crime, if you will, on the fraud conviction. I think there's no doubt this stays. Okay, well, we're going to keep an eye on this to see if the appeal gets any traction. We do watch these cases after appeal. Thanks a lot to the panelists for joining us on the Debrief tonight. We'll see you tomorrow starting at 5 o'clock here on the Debrief. Our live trial coverage picks up at 9 o'clock in the morning. See you then.